Welcome back. The Constitutional Court will today deliver judgment in the high-stakes case between Vodacom and Please Call Me inventor Nkosana Makate, which could put the matter to bed. It will rule on whether the Supreme Court of Appeal acted beyond its jurisdiction in setting aside a 47 million rand settlement offer made by the telecoms giant to its former employee. The legal battle has spanned over 20 years. Joining us now to unpack the legal and IP implications is a copyright expert, Professor Owen Dean. Prof, a very good morning to you. Thank you so much for making time for us this morning. I was going through the timeline of when this matter had started, and we are now standing at around, it's been a quarter of a century, which for me just highlights, I guess, the complexities of the matter that we're dealing with here. And also, it's not the first time that this matter is before the Constitutional Court. Of course, the first battle was around whether indeed Nkosana is the inventor of Please Call Me, and later on how much that compensation should then be, which is where we currently find ourselves at. What do you read into this complexity of this matter?
Well, it's actually an unusual matter in the sense that it's not strictly speaking intellectual property. Intellectual property governs fields of laws like copyright, patents, and so forth. Now, this kind of situation falls a little bit between the cracks of the various forms of intellectual property. The closest to intellectual property, or the closest form of intellectual property, is copyright, but it doesn't qualify for copyright. Copyright doesn't protect ideas, it protects the material expression of ideas. So this case is actually based on a contractual issue. It was argued by the inventor that he was reached an agreement with Vodacom that Vodacom would give him a proportion of the income that flowed from the use of the Please Call Me process. And so the whole case turns on whether there was a contract, and if so, what the terms of the contract was. It was never reduced to writing. It was a verbal contract, and it's often said about a verbal contract that it's not worth the paper that it's written on. But in fact, the court held, eventually, the Supreme Court of Appeal held that there was a contract in existence, and then it became a question of how much of the income from the use of the system should flow to the inventor. And that's where the matter currently stands. It really turns on, at this point, on how much. That's the main issue.
Yeah, and before we go to the matter around how much, the question around I'm employed by Newzroom Afrika. I come up with an idea, and then the company benefits from that idea. Of course, I am in their employ. The big question I remember at the time with this debate as well was whether the idea belongs to the employee or the idea belongs to the company that the person is employed with.
Well, that question comes back to the issue of what form of protection are we looking at. If it was a copyright matter, then it would be clear that if you make a work in the course of your employment by a company, the company owns the copyright in the work. The operative words are in the course of employment. If you're doing something during the time that you're employed, but it's not something that you're employed to do, then that rule doesn't apply. But because it's not a copyright issue, that falls by the wayside. And there's no general principle that an employer owns the work done by an employee. One has to look at the terms of the contract. And in this instance, as I mentioned earlier, it has been found that there was a contract in existence that if Vodacom used the system, then the inventor would be entitled to a cut of the proceeds, so to speak. So it's purely a contractual issue. There's no general principle involved here. It's only a question of what actually was there a contract, and if so, what did the contract say?
Yeah, and then comes the question around fairness and what fairness means in a case like this. Makate's lawyers are saying that the Please Call Me service generated over 201 billion rand. This is just over 10 years, and they believe on that basis that there should be at least a 9 billion rand that is paid out to him Of course, the Supreme Court of Appeal has set aside that 47 million rand. But how do we determine fairness from the creative element? It is my idea, I contributed towards the idea. But then on the other end as well is the idea is just an idea without any resources. Up until those resources are put to make the idea actually come to life, only then can we start generating money and income from it. Then how do you determine what fairness is in such a case? Also considering that Vodacom is still using Please Call Me and has also distributed it to various other countries where it's operating.
Well, what constitutes fairness in this situation is the proverbial million-dollar question. Normally, when one enters into an arrangement like this, one would agree on some method of calculating the remuneration, say 5% of the proceeds or 10 or 20, whatever percentage. That doesn't appear to have taken place in this case. There was just a general sort of understanding, so says the inventor, that he would be entitled to some form of remuneration without specifying exactly what it was. So for the court to decide what's fair in this situation is really a very difficult thing. It comes down to a discretion, and the court must decide what it thinks is fair. If I were to be in this sort of situation, if I was the judge, I would say, well, what would be the going rate for a royalty in this type of situation? Would it be 5%, 10%, whatever percentage? Find some objective standard and then apply that objective standard. But whether the court is going to use that formula or not, I don't know. That is the formula that's normally used in intellectual property.
Yeah, and with this case, once again, as we said, it's not the first time that it is before the Constitutional Court, is again the ability of the court to make that final decision. Because the last time the Constitutional Court had said that the executives of Vodacom must go and determine what that payout should be. And obviously from that flows the dispute around what the actual amount should be.
Yeah, well, it seems to me the court was a little bit at a loss as to what yardstick to use. So it said to the parties, you go and negotiate and come up with something. And then what transpired was that the court was not happy with the figure without really specifying what it should be. So it really is up in the air. It's as I say, it's a discretionary thing, and it's the court is just going to have to just make an estimation of what it would considers to be the appropriate figure in the circumstances. As I say, if I was faced with that decision, I would look around and try and find some sort of formula, like a percentage of the, a reasonable percentage, one which is the going rate in the type of industry as to what the percentage of the royalty should be. Once you settle on the percentage, then it's a question of arithmetic.
Yeah, and if you were to put your head on the block here, Prof, what would you say? Do you think that Makate will be successful in this? And of course, this matter has been brought by Vodacom, trying to overturn that Supreme Court of Appeal decision, setting aside the 47 million rand. But do you think that Makate, who is fighting this application, could be successful?
I think there's a prospect that he will be successful. The Supreme Court of Appeal is a commercial court, and it has experience in these sorts of things. And I feel that the Constitutional Court, which is not a commercial court, should be slow to set aside something which has been decided by the Supreme Court of Appeal. When the Constitutional Court was created, which didn't exist under the old regime, there was a bit of confusion as to where the jurisdiction of the Supreme Court of Appeal ends and where the jurisdiction of the Constitutional Court starts. And that gray area has been a bit problematic. And the Constitutional Court, I think, my personal view, should be slow to enter into commercial issues. And therefore, it ought to be guided by what the Supreme Court of Appeal has decided.
Yeah. And finally, I would like to ask what you read into this. When Vodacom issued a statement that they will be appealing the Constitutional Court judgment. This is what they said. The impact of the Supreme Court of Appeal's decision, if it is upheld, would be the vast and wide-ranging on both Vodacom South Africa as well as Vodacom Group, as well as the attractiveness of South Africa as an investment destination. One, it will negatively impact our employees, true shareholders, and Vodacom's contribution to public finances. It will also have an impact on our network investment coverage and social programs. So what for me, this read almost as if Vodacom is saying to the justices, that if this matter is not overturned, it will have an impact on how much we are able to contribute to the coffers of the state, and also the impact that this will have on our shareholders.
Well, obviously, they are not happy to be paying vast sums of money, and it must impact on their profitability and all of their activities, which they base on their profitability. So I can understand that it's a big issue for them. But at the end of the day, to me, the message that emerges from this whole exercise is that when this type of situation arises, a proper agreement should be entered into, and reduced to writing so that all the parties know where they stand. This whole matter has come about because it was dealt with by Vodacom right from the outset in such an airy-fairy manner, which led to all of this confusion and uncertainty. So I think it's overstating the situation to say that there's going to be a catastrophe to the future. I think what one learns from this is do your homework properly and make proper agreements.